Today, I have the pleasure of welcoming back Dylan C. Penningroth, a fellow here during the 2013-2014 academic year, to discuss his latest book, Before the Movement: The Hidden History of Black Civil Rights, which has already won several prizes. Dylan is a professor of law and history at UC Berkeley and currently serves as Associate Dean of the Program in Jurisprudence and Social Policy in the law school at Berkeley. His first book, The Claims of Kinfolk: African American Property and Community in the 19th Century South, won the 2004 Civil War and Reconstruction Book Award from the Organization of American Historians. His articles have appeared in both law reviews and historical journals. He's held fellowships from the National Endowment for the Humanities, the National Science Foundation, and the MacArthur Foundation. Joining Dylan in conversation today will be my colleague, James T. Campbell, the Edgar E. Robinson Professor of United States History here at Stanford, whose publications include Middle Passages, African American Journeys to Africa, 1787 to 2005, Slavery in the University, Histories and Legacies, and Mississippi Witness: The Photographs of Florence Mars. Jim is currently completing a book on the Mississippi Freedom Movement in History and Memory. So without further ado, Dylan, welcome back to the Humanities Center, and we are looking forward to hearing about the new book.
Thank you so much, Roland. It's good to be here. Can you hear me okay?
Yes.
I just want to start by saying thank you again to you, to Eric Ortiz, and to the whole Humanities Center team for getting this show on the road, and especially Jim Campbell for agreeing to have this conversation with me. And of course, to all of you who are watching and listening from out there, thank you for spending this hour together with us. I actually wrote most of the first draft of this book at the Stanford Humanities Center, and I'm very grateful for the opportunity that I had back in 2013-14 to be a fellow there. So I'm going to talk for about 15 minutes or so, and because it's always fun to show as well as tell, I'm going to share some slides, and I'm going to see if I can do it well. So I thought I would spend this time telling you a little bit about what this book is about in broad outline. And it's really got sort of two big ideas in mind, or two big goals. The first is to tell a story about how Black people used law and talked about law and thought about law over a very long time period, from the 1830s to the 1970s. And so it tries to offer a different model for writing about African American history. And it also wants to tell a story about civil rights. So let me talk about the first thing, a different model for writing about African American history. And I'll talk about that through the example of some relatives of mine, my great aunt and uncle, Annie and Thomas Holcomb. And here they are. It's a picture I have on my desk. And this is something, a set of events that happened a little before I was born. So my Uncle Tom and Nana, they're from Cumberland County, Virginia, and they had been living in South Orange in 1965. They had been living there since about 1927. And in the 1950s, they started getting ready to go back to Cumberland County. They wanted to move back home and spend their golden years there. And so what they did is they started buying out Thomas Holcomb's relatives who owned a bunch of land down there together in common as a family. They started buying out his relatives using friendly partition suits, and they did this at the Cumberland County Courthouse. So every year since 1927, they had been sending money south for taxes to Thomas's brother, Robert. Then in 1961, Thomas's niece, Arnitha Holcomb, demanded credit for certain tax payments, claiming that her father, Robert, had paid them. And so Uncle Tom decided, after going back and forth about this, decided that his brother, Robert, had been misrecording his tax payments under his own name. He got very upset. He decided to sell the whole thing that they'd been assembling and cash out. Then he hired a white lawyer, William C. Carter, to file another partition to get this done. Then he changed his mind. He told Carter to stop the auction and pull the land off the market. Carter went ahead anyway and sold it to a white couple named Ferguson. Now Thomas Holcomb sued Carter for failing to follow his instruction to stop the partition, and he hired the premier civil rights firm in Virginia at that time, Hill, Tucker, and Marsh out of Richmond. So what do we make of this story? Well, it's obviously a story of Black land loss, and many of you have read Ta-Nehisi Coates. He famously explained stories like this as plunder, a moral wrong that requires reparations. Now, Coates is writing in a grand tradition that frames African American history as an unfinished freedom struggle, a journey from second-class citizenship to full citizenship, from Black fear in the face of white lawlessness to Black people defiantly asserting their rights under the law. This story isn't wrong. Police are still killing Black people, and movement-centered scholarship is as urgent and necessary today as it was in the 1960s. But there are costs to this way of thinking about African American history. One is that it tends to make Black history more or less equivalent to race relations, as if Black lives only matter when white people are somehow in the picture. So, for example, it focuses on an ideal of the Black family rather than the complex reality of privileges and duties within actual Black families. Second, this way of doing African American history tends to lay a burden on this field that few other scholarly fields have to carry. It urges us to judge our ancestors according to how well they advanced the freedom struggle. Most of all, it's shrunk our vision of Black life down to the few areas of Black life where federal law and social movements made a difference. So in this freedom struggle story, the legal system before the 1960s was dominated by racist state and local officials who refused to recognize not only Black people's civil rights, but their basic human dignity and even their lives. So law, of course, was a hostile, fearsome power to be avoided whenever possible. Then in the 1940s, a few brave lawyers ventured south. They confronted the system with a carefully planned series of strategic lawsuits. And then, according to this story, ordinary African Americans, their sense of possibility awakened by Brown versus Board of Education, Topeka, and other Supreme Court victories, and galvanized by racial justice activists, coalesced into a mass movement demanding that the federal government force those racist state and local officials to recognize Black people as free, full members of American society. This is the master narrative of civil rights. In this narrative, Black people are actually seen as heroic and ordinary precisely because they knew so little about law. But if that's so, then why, when a mass movement against racial injustice finally took hold in the 1950s, why did so many Black people put their faith in law at all? Civil rights history has left Black people disconnected from our own legal common sense, the way we actually think about and use law in our daily lives. It's made it harder to see Black people as people in full. When I asked one of my older relatives in 2016 why Uncle Tom and Aunt Annie didn't move back to Cumberland, he said it didn't have anything to do with this sale to the Fergusons. My relative said the land was stolen from Nana and Uncle Tom after he put it on the market, but, and I'll quote, he put it on the market because he had had an argument with his nieces. Okay, so the second goal of this book is to tell a story about civil rights. So the heart of the book is actually a fairly simple empirical finding that has pretty big conceptual implications. The empirical finding is that African Americans use civil rights all the time. They just weren't the ones that we think of today as civil rights. They weren't about protection or discrimination on the basis of race, sex, or other protected categories. Instead, these were basic rights of contract, property, and standing, what one of the framers of the 14th Amendment called the ordinary rights of a freeman. And these, of course, are the rights that Congress wrote into America's first national civil rights law, the Civil Rights Act of 1866. And then during the grim years of Jim Crow, people exercised these rights not just in court, but also in their daily lives, although they rarely had any reason to call them civil rights. So when my great-great aunt Annie Holcomb paid my mother's burial insurance policy each week on her doorstep in South Orange, when she and Uncle Thomas paid their share of the land tax on their family land, when Thomas sued his white lawyer, and when he sued his niece, every time they did something that a court could protect, they were doing civil rights. They were exercising freedom, making it mean something more than the negation of slavery. You might say that civil rights were rights of everyday youth. And now the meaning of civil rights changed over time. It changed from these rights of everyday use, the rights of free men, into something new and different, the right not to be discriminated against, a special, set-apart body of law. Now, those of you who have read in 19th century history, and especially Eric Foner, Kate Mazer, you will know that in the 19th century, when Abraham Lincoln is running for president, that most Americans understood rights as coming in three flavors. There are civil rights, there are political rights, and there are social rights. The last two were off limits to African Americans, political and social. And the traditional story tends to focus on those. I decided to focus on the civil rights, and I started with this simple question: did Black people go to court? Now, right away, I ran into a big problem, which is that legal documents don't typically identify people by race, not even in local county courts in Mississippi, not even in 1900. This, of course, is kind of a surprise, right? Because even the water fountains are segregated in those days. Now, there's some big analytic and conceptual issues here. But for the time being, I'll just say that the immediate issue I faced at the outset of this project is that it was very practical. I wanted to write Black history, but I couldn't tell who was Black. And so to get around it, I would hop in the car, or I'd get on a plane and hop in a rental car, and I would spend a week or two visiting county courthouses. I would show up at the office of the circuit clerk, and if they let me in the back room, I would start pulling down docket books like the ones you see here at 10-year intervals, and I'd copy down the names on a subset of the cases for that year. And I gave these cases then to my research assistants to look up on Ancestry.com, right? So you know about the swabbing your cheek. This is the other part where you're typing in names into the fully searchable US Census. Once I had a list of cases involving Black people, I then went back to each courthouse and I read some of them. And this is kind of what the docket books and some of the loose papers tend to look like. Now, of course, this was not a foolproof method. You can see why. No historical method is. And sometimes it was kind of gnarly, but gradually we started seeing a picture of when, where, and why Black people used the courts. And by the end, we looked up more than 14,000 civil cases from 24 courthouses in 5 states and the District of Columbia, and we identified more than 1,500 that involved Black people. So, race ducks in and out of the Westlaw and Lexis reports that practicing lawyers and most law scholars use, and it's pretty much invisible in the county court dockets. This is how we made it visible. Now, Black people used the local courts for all kinds of things, a lot like white people did. They went there to get divorced. They went there for insurance payouts, railroad accidents, unpaid rent, and personal property. They used private law in more routine, non-adversarial ways too. So they did things like sold easements on their land. They made wills and got them probated. They had cars towed off of their property. They sorted out home building contracts, drunk driving charges, landlord-tenant disputes, and of course they bought, sold, and gifted land. And then they talked about it in church sermons and newspapers and over back fences. Now, why does this matter? There are a lot of reasons you could point to. I'll just mention a few here. First is that knowing that Black people were using courts and thinking about Black history in this way can help desegregate American law. Let me explain what I mean. In the 1960s, the story of civil rights, the public meaning of civil rights gets sacralized. And that made it hard to see Black people's presence in the very areas of law that are and were at the heart of the law school curriculum, which you learn in the first semester of law school. Contracts and property. These are the flagship courses. These are essentially what the Republicans had written in the Civil Rights Act of 1866 as the rights of free men. But they typically get taught in law schools then and now as if they were white. In the 1970s, there was intense pressure from students. Most of the top law schools were introducing new courses on things like Blacks and the law and civil rights and poverty and minority law, legal problems of the poor and consumer credit. And the first year courses were also starting to cover various kinds of inequality, but the curriculum still stumbled when it came to race. It tended to equate civil rights with minorities, implying that contract law and property law were not civil rights. In other words, by treating civil rights as a special minority-focused body of law, the law schools veiled what cases brought by Black people had contributed to core areas like contract law. They implied that Black people encountered law meaningfully only in criminal justice, voting, the workplace, schools, and public accommodations, that is, in cases about race. So the second reason this story of Black legal lives matters, I think, is that it opens up ways of rooting present-day movement activism in a deep history of Black legal activity and Black legal thought. Now, I want to be clear. Property and contract were tools. They were not saviors. And in that realm, and I'll just quote the sociologist Mark Galanter here, the haves come out ahead. Or as Billie Holiday put it, them that's got shall get, them that's not shall lose. So this is not a lament for the path not taken. What I'm trying to do is to replant a familiar story in the soil where it first grew. But how? Well, one way to do it, I think, is to to look closely at what you might call a bottom-up history of legal thought. Legal thought is usually thought of as something that belongs to elites. But if you look at working class people's discourse about law, it really reveals a lot. And so I think that if you want to understand why, for example, only 17% of Black Democrats consider themselves liberal, why Justice Clarence Thomas thinks eminent domain is just a fig leaf for what he calls Negro removal, we have to look at what Black people actually think about law. Not just the rights that America denied them, but also the rights that were not denied to them, the rights of everyday use. But I think the third and last reason that this story of Black legal lives matters is that it opens a different perspective on Black life itself. And to see it clearly, we have to take seriously Black social relations, including inequality and subordination among Black people. And that means seeing Black people's political and economic and religious and family commitments as something more than episodes in race relations, more than echoes of America's original sin, more than signposts on the road to a more perfect union or facets of a struggle for Black freedom. You could say that my basic premise is that Black people's lives are worth studying in themselves. So I'm going to invite Jim Campbell to come in now, and we can start our conversation. Thank you for bearing with me.
Well, thank you. That was just marvelous. One of the things it did was answer a lot of the questions that I hoped to get you to discuss. But I guess I'd ask you to start maybe by telling people a little bit more about your sample and how you devised that sample. How you've mentioned how you went through, I think you said 14,000 cases, identified those which involved Black litigants. But the map you showed us clearly shows you chose particular counties. You mentioned taking samples of particular years. I just would love to hear more about that.
Sure. No, that's a great question. So to be clear, at the beginning, I had to do a bit of a proof of concept. I had to sort of surf around and figure out a method for finding any cases. And this was in about 2003, 2004, and there wasn't a searchable database of the census on ancestry. So I was, going back and forth to CD-ROM drives and microfilm. Uh, it took a while. And so at the beginning, this book was really going to be about Virginia and Washington, D.C. Um, how did I choose the locales to study once funding and technology became available that allowed me to do a bigger, somewhat more national study? Um, I wanted to pick states that fell along at least two of the axes of the Great Migration. So if you think about the map that I shared with you earlier, Virginia has a diaspora going up to New Jersey, New York. And of course, that's the route that my family traced. Mississippi, as Jim Grossman and so many others have shown, has a diaspora going into Chicago and Illinois. Um, and so those four states, plus North Carolina and DC, that's the reason I chose those four states. I tried to choose counties within those states that would give me something like a representative sample of the states according to demography. So I picked counties that contained high percentages of African Americans and more modest percentages of African Americans. Chicago and Newark, New Jersey, Essex County, they actually contain almost no African Americans, like fewer than 3% African Americans for most of the period that I'm studying. It's not until like the 1940s, 50s that the numbers really climb. And so I chose counties based on demographic criteria. Then there's one more practical reason, which is I needed to go places where the record still existed. And then the last one was sort of practical. I liked going to see my family, and so I made darn sure that I got to go to Cumberland County. So that's how I chose the counties.
I think that's one of the things that's really powerful about the book actually is it's on the one hand, immensely erudite work of scholarship, but it's also a deeply personal book. And this is one of the things I was going to ask you about, although you've in some ways already talked about it. It's personal in at least two ways, right? Obviously, you're talking about and to your own family, but it also became clear, and you've just alluded to this, that you were talking to your law students. And I wonder if you want to pick up either end of that. This is a more personal book, it seemed to me, than your first book, and a more personal book than most of us write.
No, I appreciate you asking that. And and I especially appreciate you picking up on the personal dimension of the conversation that I'm trying to have with law students. Um, I, you know, Halfway through writing this book, I came to work in a law school, Berkeley Law, and I became aware of what seemed to be, at least to my ears, a kind of dissatisfaction that rumbled through the student body. Not everyone felt this way, but it went something like this. You know, I, the student, I sit in my contracts class and I'm just positive that there's more going on in these cases that were assigned for class than the case book shows. Now, obviously, that's true. Any case when it's excerpted, or even when it's not excerpted, it's just a slice of reality. It doesn't actually sort of represent fully the lives and the interests of the people who are appearing in court. But the students who I taught were interested in the absence of race in particular. Race, gender, sexuality. They knew that these things were out there, that they mattered in law, just sort of common sense told them that these things mattered, and yet they didn't figure into the coursework that they were taking, except in certain discrete units, most of which came up in other classes like constitutional law um, or criminal law. And so this project that I'd been writing, which I had conceived of as a project about Black people's engagement with law and this idea of civil rights that I've been tussling with as a 19th century US historian, it really came into focus for me as something that meant something not just to law students, but to legal education and maybe to legal theory as well. And so, I started writing an article that eventually got published in Penn Law Review called Race in Contract Law. And, in the course of writing that article, I discovered or was reminded that my mom had gone to Penn Law School for a year and a half and then did not finish. And it became sort of very resonant to me that this was something that was personal in my family. I don't know why she dropped out. I think there were a lot of reasons. One big reason was probably taking care of me because I was a 1-year-old at the time. But I just sort of felt like there was something resonant about the law student's experience that connected with some really big issues in legal education and legal theory. And so that's a dimension of the sort of the personal that I really appreciate you picking up on in this book.
Well, actually, it's even deeper than that. I mean, one of the things that you show, and this was just a revelation to me, is that some of the cases that show up in the case book were racial cases, and that in fact race was actually a central in understanding how they were brought and how they were adjudicated, and yet for various reasons having to do with legal strategy, the race of the participants in the litigation gets scrubbed out. You in fact refer to it as a kind of passing of these cases into just ostensibly ordinary law, when they in fact emerge out of the kind of litigation that you're talking about. So, I mean, the Byers case is an example, the Talley case is an example. Do you want to just talk about that? I think people would be very interested in hearing about that.
Sure. So I love the way that you put that question. That there's so much tied up in the way you framed it, that some of the cases in the case books were racial cases, and then race got scrubbed out. The reason I think it's so fascinating, and I'll just give an example from the Byers versus Railroad case. This is a case from 1916, I think. I'll just tell you what happened in the case. There's an African-American man named John Byers whose wife dies suddenly in another city. And so he prepares to go down and attend her burial. He buys a shroud, gloves, dress, a casket for his wife and puts it on the railroad shipping down to his wife in South Carolina. And then the railroad loses it all, just, cold loses it. And he sues for damages. And what he wants for damages is not just his lost payments to the railroad. He wants damages for emotional anguish under contract law. And so at the time in 1917, this is actually an open question. Can a person recover damages for emotional anguish under contract? Courts go back and forth about it. The North Carolina Supreme Court says, yes, you can. The US Supreme Court says, no. And what's funny about this case is that, number one, literally what is at issue, the legal issue here, is the feelings of a Black man. How do I know this? Because on the very first page of the transcript, which is provided to the Supreme Court justices, Byers' lawyer asks him a question, and Byers' reply is, yes, I am a darky, but not a slavery time darky. So the lawyer is obviously trying to get this into the record so that justices can see it. The lawyer thinks that race matters, that it matters for the outcome of this case. When the court makes its decision and publishes it, and you can see it on Westlaw, they say nothing about John Byers' race. Absolutely nothing. You can't tell that he was Black by searching in Westlaw or LexisNexis. This is especially surprising because one of the justices on that court is one of the most flamboyantly, demonstratively racist men ever to sit on that court. He swivels his chair later in a case involving Charles Hamilton Houston, so he doesn't have to look at a Black lawyer. He goes out of his way to scrub out the race of John Byers, even though he himself harbors these incredibly racially discriminatory views. What I think is going on here is that race matters when an actor in the legal process thinks that it matters. And race does not matter when an actor in the legal process thinks that it does not or should not matter. The Supreme Court wanted to scrub it out, not so that they could screw John Byers, but because this court wanted this principle, no damages under contract for mental anguish. They wanted it to sweep wider than just Black people. They wanted a holding that said it's not just that Black men can't get damages for mental anguish. They wanted to hold that nobody can get damages for mental anguish. And that's why they scrubbed it out. So there's this really interesting way in which cases that are not about race, like John Byers, are still about race. But the only way you know that is if you can see the ones that are quote unquote passing for white.
Interesting. I want to push you on something that was occurring to me a lot as I was reading the book, and you, in fact, answered it directly at the end of the book, and you included that here. And it was really about, what are the stakes of the argument, right? That what you're trying to get us to recognize, and you've said this quite eloquently in your presentation, is that Black people are not people who've lived outside the law, and that there were, I'll get to this perhaps in a moment, even under slavery, there were certain privileges, not, judiciable rights, but privileges that enslaved people enacted. You tell an incredible story about another Holcomb, Jackson Holcomb, who's actually charging fleeing Confederate soldiers to use his boat to cross the Appomattox River. And they pay him. It's his boat, even though, of course, by law, an enslaved person was property and couldn't hold property. And then you, I think, even during the Reconstruction era, you again show how there were certain, even the darkest days of Jim Crow after the collapse of Reconstruction, there were certain justiciable rights that Black people do exercise. And I guess one of the questions that was kind of occurring to me is, okay, you in that sense seem to be suggesting that what happens as we move into a civil rights era, and where you talk about the sacralization of the civil rights era and of the movement, and that our understanding of civil rights, in a sense, atrophies, it narrows, it becomes more circumscribed. We start to see it only in terms of issues of racial discrimination, and that there's an entire body of Black people exercising and litigating rights of everyday use. So what you've said just now, what you say at the end of the book is, look, I'm not saying this is the road not taken. I don't mean to be critical of the civil rights movement. I'm not saying that this is the lost promise of the civil rights of everyday use. And yet there's a ton of stuff in the book that seems to suggest that. I mean, there's tonally, you talk about, and I just pulled some of these quotes, about how as we make this move, they, Black people were inadvertently ceding the vast ground of private law and all they had accomplished. There's a number of times you talk about this as a narrowing, as a circumscription. You've said it here again, that something gets lost. The fact that we've lost this keeps us from seeing the full range of what civil rights did in the past and what they might do. So I guess, as I was seeing you, it almost seemed like grappling in real time with this question yourself as you're writing the book. And I guess I want to push you on that. If you're a historian, the mere fact, it's not a mere fact, of having unearthed a whole variety of kind of human experience, of legal experience that has been invisible to us previously, and using that quite brilliantly to open up the full range of Black associational and familial life, that's a big accomplishment. But it also seems that you are trying to somehow tell us that there was something more here, that notwithstanding what you just said, that there was something lost, that as we've moved into this, what you called a master narrative of a sacred civil rights movement, that what we've actually done is narrowed our understanding of where the struggle is and what it can be. in fact, you end the book by saying, look, those cases are still sitting there for us if we want to look at them. So can I push you on that to reflect on that a bit?
No, that's such a great question. And you put your finger on the kind of balancing act that I'm trying to strike here. Because on the one hand, I think it would be a mistake for me to say that um, that property, contract, and standing were going to solve everything for Black people, or even most things for Black people in 1900. How do I know this? Because I'm reading these cases and I'm watching Black people use property, contract, and standing to pursue their own interests, and it only gets them so far, right? Like there are these, in a way, one thing that you can do is you can sort of see this story as filling in kind of a mystery about Black achievement, right? Like you think about how do Black people found colleges, in the late 19th, early 20th century? How do they accumulate 15 million acres of land, most of it in the South? There are all these achievements that we know about, but that story is kind of at odds a little bit with the story of Black legal alienation that we tend to be taught. And so, in a way, telling a story of Black participation in law, use of law, helps reduce some of that mystery. At the same time, I think you're right. I do think that something got lost. Um, I think that in the narrowing of the concept of civil rights, or maybe you might say in the replacement of one concept of civil rights with another one, because civil rights had always had multiple meanings. One meaning for African Americans was, of course, these individual liberal concepts of rights that I've been describing. But another meaning had to do with what one 18th century legal theorist, St. George Tucker, called uh, civil slavery or slavery of the community. And Frederick Douglass actually talks about this a bit, and some of the activists talk about this. And what they're basically saying is, look, unless we have all of the rights that white people have on equal terms, then we are slaves. Like they literally use this language. We are slaves not to an individual master, but we're slaves to the community. And so I see this as kind of a forerunner to the language of second-class citizenship that you see thrown around a lot in the 1960s and 70s and even today. There's this through line that connects this concept of civil rights to something that we see more familiarly as second-class citizenship. But what we've lost is that grounding in this rhetoric of slavery that would have been completely familiar to Douglass and other activists. So there's a connection there that gets lost. And then I guess I'd say, if we're thinking about like what we as individuals and maybe as activists can take away from the story that I'm telling, from looking back to this history, I would say that it could enable us to connect what we're doing and what we're thinking about and the problems that we face to pieces of the African American past that are quite empowering if we're willing to confront them. And so one of them is the reality of Black people in conflict with other Black people. That's true in activist organizations, and it shouldn't be a surprise. It's been true all the way through. You've documented this yourself in your own work, and you know full well that in churches and in fraternal orders and, in all sorts of other organizations, Black people don't always agree. And that doesn't necessarily just undermine the struggle toward a common shared goal. It's actually worth paying attention to the struggles because through paying attention to those struggles, we can understand, we can take less for granted what the struggle was really about. So I think that's something that can empower us today.
Yeah, I think that's wonderful. I mean, one of the things that's just incredibly powerful about the book is its lack of sentimentality, right? And it highlights the way in so much of the both popular discourse and also historical writing about the Black community or the Black family. There are a set of pervasive assumptions about this kind of smoothly organic pre-political space, and that explodes. I think at one point, in fact, you say of the 1,400 cases you're working with that involve Black litigants, only, I think you said 8% of them, 1 in 12 of them, is actually a Black person suing a white person, right? That virtually all of these are suits, litigation that Black people are bringing against one another. Um, I want to, in a sense, follow up on that in a way, and it's churlish to ask about something that's not in the book, given that this is an incredibly dense, almost 400-page book. But what you've done, giving us this extraordinarily variegated vision of what Black people are, right, and the variety of them, and the variety of ways, the systems of privilege and class dynamics that operate intracommunally. It struck me that there's very little of that in regard to white people, and that white people hover here in a much more undifferentiated way. And at one level, that's understandable. It's a book about Black people. In fact, I should probably just mention this for those who haven't yet read it. One of the things that's kind of mind blowing about the book is that the characters in the book who are racially unmarked are Black throughout the book, and that I thought was just an absolutely brilliant move, because it just for me, and for I'm sure many other readers, underscores how often, when we're writing about a historical character, we say Dylan or Jim, and we're talking about a white person, and if we're not, we have to mark that person. So it's a book about Black people, I understand, but there are ways in which, particularly in the cases you're working in the South, that's a class-ridden white society. I mean, you do tell one story involving, the famous example of Nate Shaw, the subject of All God's Dangers, where one of the disputes he's in, he kind of prevails in the suit because the white rich man is trying to rip him off. Been ripping off a lot of white people in the neighborhood too. And that gives Nate Shaw a kind of purchase on community opinion that he might not otherwise have had. So I'm just wondering if I can push you on that. Did you find more of I mean, again, because you're choosing cases by definition involving a Black litigant, and most of those are intra-racial conflicts, perhaps, your sample is winnowing a lot of that away. But I wonder if you found that and what you think about that.
No, it's a great question. And it's true that in making African Americans the center of the book, I necessarily slighted the sorts of intra-white differences and tensions that are surely there. And those come through from time to time in the book. You mentioned one, Nate Shaw, with the white man, Watson, ripping him off and getting rescued by another man, wealthy man named Black. But there are others, and I guess maybe one example that springs to mind is about the tensions among white people that help underpin Black people's ability to have privileges during slavery.
Yeah.
So a lot of people have written about the slave's economy. I would actually say, and I hope I didn't use this language in the book, that it's not the slave's economy, it's the economy, because white people are participating in it too. Enslaved people are buying and selling things like brooms, cows, corn, sometimes horses, small crops. They're ferrying people across rivers like my great-great-great uncle did. And so white people are enmeshed in this economy. And I also shy away from the term the slave's economy, because that economy was essential for the profitability of the slave system overall. It could not have succeeded in the way that it did, I think, if it had not been for these privileges of slavery. And then I guess the third thing I'll say, and this comes back to law, is that it's not just the slaves, it's white people who are participating in the same system of understandings about things, rights to things, obligations, mutual obligations that we call contract and they had to call bargains. Um, they're participating in the same system of understandings about law that govern transactions between and with enslaved people. Um, and that doesn't sit well with all white people all the time. There's just a constant rumbling of annoyance and sometimes fury from white people, where they basically say, look, this is actually illegal. Someone has to stop these slaves from running around the streets of Charleston and selling things. And what they find, of course, is that it's not illegal. There just isn't a law about it typically. And so it's in that space that these battles are being fought about what's legal, which is not necessarily what the law will protect, but what community opinion will protect. And those controversies are largely between white people of different social classes.
That's wonderful. You and I could talk forever, I think. And Roland, I know we want to open this to the wider audience, and I imagine some questions are coming in. So um, I hope we get to continue this, Dylan, but let's throw the thing open to our audience and see what questions they might have. Thank you. That was great.
It was
Thank
great.
you.
And, I feel as if we should write to so many of our former fellows and tell them that, send them the recording of this conversation. It's one of the most stimulating conversations we've hosted in this format for a long time. So thank you both for this. We have several questions about something that Jim mentioned a few minutes ago, and I want to both, without repeating ourselves, I want to also do justice to the fact that people seem to want you to say a little bit more about this, and that's the notion of the sacralization of the civil rights movement. And I guess to take up one thread from one version of this question, let me pose it this way, and it's a little different from what Jim asked you. Do you think that this is a book that obviously it's a book of this moment, but do you think it's a book that we are somehow more ready for now than we would have been 25 or 30 years ago in terms of the way it changes that what you call the sacralization of the civil rights movement and enables us to see it as involving certain, not only a kind of narrative about that movement that obscures certain things or goes around certain other more complex realities. Is this the kind of book that you see as able to see, for that matter, able to see a sacralization as a sacralization at this moment in history? Or how do you see the book's relation to sort of our historical distance from the civil rights movement?
It's an interesting question. I think part of what this question is getting at has to do with shifts in the field of African American history, which make possible certain kinds of arguments and maybe, other sorts of arguments less interesting to those of us who do African American history. In that sense, I think, yes, it probably would have been more difficult to write a book like this 25 years ago. But in another sense, no, because I started this book 20 years ago and I knew I wanted to write about this stuff. So, whenever you start out on a project, like you have a certain vision of what it could become. And, very quickly you go to the archive and that vision changes drastically because you don't find what you hoped you would find. You find something else. But that part of my vision has stayed consistent. It actually was part of my first book as well, and that is just looking very carefully at relations among Black people as being complex and complex in ways that I felt at the time were not really being captured in the scholarship. But on the particular question of sacralization, what do I mean by that? Maybe I should explain what I mean by that.
Yeah, that's the drift of several of the questions.
Yeah. So Um, you know, I guess at the most basic level, what I mean is that in, the 1950s, a mass movement emerges, um, pursuing something called civil rights, or freedom, and eventually freedom of the human spirit. Uh, and many of its most prominent leaders are Black preachers. They're men of the cloth. Um, and many of you may, also all the sorts of complications that result from that fact, right? Like the historiography has had, years to, grapple with, do we tell a top-down story from King and Malcolm X, or do we tell it from the bottom up and so forth? What I'm pulling from here is just sort of that starting observation that, at least in the public discourse of the time, the most prominent leaders of that movement were ministers. They were Christian ministers, and sometimes non-Christian ministers, Muslim ministers. And those ministers literally wrapped their movement in their faith. King would say, I've been called by God to preach, civil rights to my people. And I don't care who says we should not preach civil rights in that church. I'm going to do it anyway because God has, has called me to do this. And, yeah, maybe. But there are a lot of people in other churches who did not want their preachers to do that. They did not feel that God had called their church to put its property and its lives on the line for this thing that might result in their deaths. And so there's this way in which civil rights gets lifted up from these mundane, ordinary rights of property and contract, the insurance contract that, my aunt is signing on my mother's, her burial insurance. These are mundane things, and Black lawyers handle mundane things all the time. That's what Black lawyers make their living by, is Black people coming to them with just wills and estates, divorce. And so in the 1950s, 60s, those things, they're still going on. Black lawyers are still handling them. My aunt and uncle are still owning land, but it's no longer identified with this term civil rights. Civil rights is now something that is a holy struggle. It's a very moral struggle. Racial injustice is a moral struggle. That's true. It's absolutely true. But what I'm interested in is what gets forgotten when we think about civil rights in those terms. It's still going on. We just aren't thinking about it or even looking at it anymore.
Just a quick example of this. You talk about this and drawing on Marcia Chatelain's book, Franchised, right? That the emergence of a franchising system that has not only had kind of deleterious, ostensibly as an opportunity for Black uplift when we see the proliferation of franchises into quote unquote ghettos that become a way of, in a sense, extracting wealth out of Black communities, and with lots of other things as well. That is not an obvious problem of racial discrimination. It's not like Black people are being denied the right to have franchises. But so there's a set of legal struggles around what are the rights of who's on the hook if a franchise goes under or burns down, and so forth, that are not obviously civil rights struggles, but have immense kind of consequence. I think part of what your work does is allow us to kind of recover other places where the struggle is happening that don't necessarily fit in this vision we have of a holy freedom struggle.
And I love Marcia Chatelain's book. It's a terrific book. You should go buy it.
Yeah. What else do you have, Roland? Other questions?
Here's another question. Yeah. So Dylan, one way to think about this project is that it is a kind of ambitious exercise in rendering visible things that have been invisible for a long time. And one of the audience members wants to ask you, What advice do you have for other historians, not necessarily legal historians, but people that are thinking about projects that entail a kind of making visible? What are the challenges you deal with in that? What are the workarounds that have helped you? What are some of the things that sort of, make it possible to write a project like this?
Oh, yeah. That's a really tough question. Rendering visible, I think, often gets glossed as recovery, um, recovering facts about the past that have gotten lost. And a lot of the conversation that I've been, you know, engaged with for the past few minutes, I think can fall into that category. But it's the meaning that we bring to it that makes it something more like what the questioner was asking, rendering visible. Because just pulling up these documents doesn't really mean very much in itself. I remember having a conversation with Laura Edwards early on, and I just started, it was starting to dawn on me that I could actually identify cases involving Black people. And I wanted to document this and write about Black people encountering courts. And, her response to me was something like, that's great, but you need to have a point. It needs to add up to something. Um, and that, I think, is maybe the biggest challenge, is that, there's this act of recovery, but then there's sort of the meaning that we are trying to make from it. And as I said earlier, you know, you don't go into a project with a blank slate. You have an idea that you're, or a problem or a puzzle that you're trying to solve. Um, and then it changes when you get in there. Uh, but at the same time, when you're confronted with these documents and you've recovered things, that is a really big challenge, figuring out, what does this add up to? So I'm not sure I have a really great answer
Yeah,
to
no, that's
to
fine. That's
rendering
fine.
visible.
And yeah, and let me just remind our audience, we have about 20 minutes left. If you do have a question for Dylan and or Jim, please use the Q&A feature in Zoom and send it along, and we will try to get to it. Related to what you just said, Dylan, is you mentioned at the beginning of this event that you wrote the first draft of this book when you were at the Humanities Center, which was a little over 10 years ago. Could you tell us something about how some of the twists and turns that your own sense of the argument took along the way, as you discovered things that you perhaps that you weren't expecting to find, or things that ways that the conception of it changed along the way?
No, I really like that. So one thing that changed along the way is I started to I started to think that I wanted to put my family into it explicitly. I didn't make that decision finally until maybe 2 years ago,
Mhm.
when I was working with Dan Gersel at Live Right, and he kind of gave me permission. You can do this. Like, don't do it too much. Don't deceive people into thinking that this is a family history, but you can do it judiciously. But the seeds of that were kind of stirring for me while I was at the Humanities Center. Um, and so that's one thing that changed along the way. Um, Another thing that changed along the way was making the study much bigger.
Mhm.
You know, a few years before I went to the Humanities Center, I got a National Science Foundation grant um, with the help of the American Bar Foundation grants staff. They're amazing. And that enabled me to expand the study beyond Washington, D.C. and Virginia, and make it like, 4 states and District of Columbia, make it kind of more national. So that's another thing that changed. And then I suppose, a third thing that I'll flag as being a change is that I became interested in corporations. Jim was getting at this a minute ago when he talked about the franchising. Um, I, I became aware that uh, some of the story of collective action and collective thinking that I was seeing in these documents could connect to the story that I knew from the scholarship about the freedom struggle through corporations. And the reason is that, and I came to realize this, the major Black activist organizations of the 60s and 50s were corporations, and that there was this long history of corporations going back to the 1790s, many of them churches, but also business organizations. And so I started trying to dig into that, again, recovering this history that at least I didn't know about of Black people using the power of incorporation to get stuff done that they cared about. Um, and then connecting that to the freedom struggle story, which again is true and vibrant and something that that still needs tons of work in. And so that was a third thing that I became really interested in while I was working at the center.
You know, I
Here's
want
Go ahead, Jim.
yeah, throw something out here that I just to draw you out more on this. One of the things that is really interesting about the book is, you know, you're in a variety of ways expanding what we tend to think of as rights. I mean, part of the argument of the book is when we think of what my rights are, what civil rights are in particular, um, we have a very presentist vision, and you're reminding us, kind of in the spirit of, I guess, scholars who call it legal pluralism, that there's a much longer changing ideas of what constitute rights, how those are defined, many of which operate in a sense through community opinion as much as through any kind of written deed or statute. Um, you know, and what have you. But one of the things that I was really quite new to me, a lot of this book is about association law, about not the rights, I mean, or rights in quotation marks, the privileges that people have as members of collectivities. And we've talked a little bit about churches, which are one of the things, but there's multiple, you know, burial societies, businesses, fraternal orders, and indeed families. You know, the problem of heir property, as you call it. You know that so much land is held in titles that are essentially associational. And so I guess I wonder if you can talk about that. That to me was one of the most revelatory portions of the book. It just, I mean, I've written a book about Black churches, and that had just never occurred to me.
Yeah, it really blew my mind too. I mean, it blew my mind in part because I grew up in the Black church, and you know, I don't know, I was young, and so I wasn't on a deacon board, I guess. If I had been, I would know, wouldn't be surprising to me. Um, but yeah, you know, most Black churches are corporations. You know, in a way, once I say that out loud, it kind of demystifies that word corporation. You know, it's not just ExxonMobil. Um, it's Stanford University. It's Bethel AME in Philadelphia. It's First Baptist Church in Princeton, where I grew up. So, you know, the idea that Black people are making corporations and using them, I thought was really exciting. The interesting part for me, too, one of the interesting things about it is that Black people have to make a choice about whether or not to incorporate. And turning your association into a corporation, formally into a corporation, endows your group with certain enormous powers. You can hold property. You know, the corporation can hold property for you. It can make contracts. Its president can speak for you. Like that. That's why Martin Luther King can speak for the Black people of Montgomery, because he is the president of the Montgomery Improvement Association in 1956. He gets to speak. No one else gets to speak for the MIA. If they try, they're not listened to, because he's the president of that corporation. And so, but incorporating also means that the members of the corporation have to give up certain rights. They can't speak anymore in the name of the MIA. for example. They can't own the property together um, with other members of the MIA. It's now vested legally in the trustees of the MIA. And so when Black people make the choice to incorporate, they're bringing law in a way that structures their relationships with one another in an incredibly unequal way.
Yeah.
Some people have rights, other people just have privileges. And the people who have privileges, by and large, in many of these Black organizations, are women. And the people who have rights are the leaders, and they tend to be men. And that is one of the through line themes that runs through my book. The ways in which forming a corporation both empowers Black people to fight the freedom struggle, to struggle against white oppression, and at the same time, it touches off, or maybe let's say intensifies, inequalities and dissent inside Black collectivities. I'll say one more thing about your idea of me picking up on this as an expansion of rights. And there's a little, I'm doing something intentional there that maybe matters more to law professors than anyone else, but I think it might matter to many of us. And that is that in the 70s and 80s, a lot of legal academics associated with something called critical legal studies movement, the crits, they came to believe that rights were indeterminate. Just at bottom, rights, you can't pin down what a right is. And that number two, that rights were not only not liberatory, they're not going to liberate people having individual rights, but that they might actually undermine people's ability to fight against systems of oppression. And Patricia Williams, a brilliant legal scholar at Columbia, wrote a really influential book where she essentially said, yeah, I get it, but you know what, for people who have never had rights and whose rights have been in question for so much of their history, rights still taste delicious in our mouths. And, I took that to heart. And so you're right to point to the ways in which I'm really interested in rights, as well as being conscious of their limits.
Well, this connects to another thing that we didn't really get enough time to talk about, but I don't even know if the word ever appears in the book, but there's a federalism issue that's unfolding all of these times, that the basic rights of contract and property and standing that you're describing are established in state law and are adjudicated in state and local courts. And my window on the world right now is Neshoba County, Mississippi. That's where I spend a lot of time in the courthouse. And that's a really tough case for people to get anyone in those courts to listen to them, right? And so, as you point out, part of what happens here is the federal government occasionally offers Black people, as you say, a latchkey into federal courts, and it does it in 1866 with the Civil Rights Act, and then later with the 14th Amendment, and then it does it again in the kind of triumphal, the achievements of the modern civil rights era, the Civil Rights Act, the Voting Rights Act, and the Fair Housing Act. But in effect, that in a sense, this helps to explain perhaps why this tradition you're describing gets kind of pulled apart, right? Is that the cost of admission, the way you can get them to open the federal courthouse door to you, so you can make a claim, it has to be a discrimination claim.
Yeah, I think that's right. That's absolutely right. But at the same time, Black people continue to bring all those cases in state court that aren't about race, or which are about race, but they're not framing them as being about race. So I see these federal cases as kind of opening up a new set of possibilities for aggrieved Black people, let's call them, to get into court, to litigate things that they care about. But like I've been saying, they continue to care about property and contract. They continue to bring these cases in state court. And, sometimes the things that they're litigating in state court actually borrow some of the rhetoric from federal court. This rhetoric of equal protection. This occurs occasionally in cases involving church membership. But I think you're absolutely right that the price of the ticket to get into federal court in 1866 and today, arguably, is you have to bring a claim of discrimination. Now, how open are the federal courts now and going to be in the future to such claims? It's an open question.
Yeah, I think that's exactly right. I mean, I was thinking, again, forgive me for talking about the stuff I've been thinking about, but literally this morning was working on a portion of the book I'm writing about, and your book just completely changed my way of thinking about it. Right? It's basically a case in Neshoba County in Philadelphia, Mississippi, which was where the kind of notorious murder of the 3 civil rights workers was. And in the aftermath of those murders, the movement, COFO, basically decides to open a project in Philadelphia, Mississippi, and they rent an old abandoned, or they lease a hotel in the black neighborhood. And it takes about 24 hours for the Klan and the local authorities, sheriff and deputy sheriff and county attorney and all of these people who were implicated in the murders, to come there and serve them with an eviction notice. But what was fascinating to me about it that I'd never paid any attention to is, the attorney who's there serving the eviction notices with the sheriff is the same person who had written up the lease for the black man who was renting the hotel previously. And the struggle actually becomes whether they can get that black man to bring a case to evict the movement that's in there now.
Yeah.
And so there's this,
Because he's the tenant and they're
yeah,
subtenants.
exactly. And so what you end up with is a situation in the most lawless corner of Mississippi at the most lawless moment, where the same lawyers are involved on he's getting a fee from the guy who leased the thing, who he's now trying to get to do their dirty work in evicting these tenants. And it's just, and so and that's exactly the kind of stuff that I and other historians, when we look at this, we just read past it. This is the evil law coming down on these people who are, trying to open a freedom school in the aftermath of these murders, just not there. And yet there's this entire kind of interior history about law and deference, even then, to the fact that if this is a legitimate lease, you can't throw them out, right?
No, I'm really glad you brought that up, because there's sort of a hopeful story and a not hopeful story in what you just said. The hopeful story is, look, law mattered, and that, white lawlessness cost white people something, right? Like if you violate property rights, if you violate the rights of a subtenant, you're going to have to clean up the legal mess that leaves behind. If you lynch a landowner, you've got a break in the chain of title. It's possible to fix it. There are ways to do that, but it costs somebody money. So that's kind of the hopeful story, right? The not so hopeful story is, and I'm going to assume that they eventually did get this, that they got COFO evicted, right?
Well, there's another even more appropriate wrinkle. Of course,
Yeah.
There's movement lawyers who are inside the hotel at the time, and they're kicking the thing into federal court.
I see. I mean, that's fascinating. I can't wait to read more about it. And I suppose the code of what I just said. Yeah, it's just.
I was writing, you've just blown up for me, so I've got to rethink it. But
it comes back to that lost promise question that you asked earlier, and others asked too. It's like, Black people exercised rights, these rights of everyday use, and white people still held most of the cards. For me to say that Black people could exercise some rights is not to say that they came out ahead all the time, or most of the time, or even half the time. They still they start with a smaller pile of chips, smaller pile of legal endowments at the beginning of most cases, especially when they're up against white people, than the person on the other side of the table. If you go into a contract negotiation over employment with a boss who can afford to just sit and not give in, you have to pay rent. So you're going to agree to a contract that you may not like because you can't hold out as long as the boss does. So having these sorts of rights, it's not a panacea.
Roland, do you have another question? Because I can keep going, but I don't want to monopolize.
Go ahead and ask one more, Jim, and then I'll try to slip one in from the audience before we finish.
I guess this is because you've just touched on something that I've been wanting to ask you here, right? Is that, I mean, there's a question here about again the equipoise, how the argument lands, right? So what you're showing us is that Black people were not systematically as excluded from the law and from rights, both or privileges and rights, that we thought that they exercised certain privileges even as enslaved people, and that they exercised certain basic civil rights, ordinary rights that were profoundly meaningful. Um, but the problem here is you also are at great pains not to minimize what, in effect, what you've just said, the fact that this isn't law as somehow this blindfolded figure on the steps of the courtroom in an equal balance, right? And you certainly don't want to minimize the brutal realities of either slavery or of Jim Crow, right? And so part of what happens in reading the book is it's one of these books where you make assertions and then are very quick to backload qualifications, right? And I think you handle that very well, but it does beg the question: how much does this legal world that you've uncovered really matter? To what extent does it actually materially change the lived reality or the lived experience of living under a white supremacist regime for people in the Jim Crow South? And I mean, just you can answer that in general, or some of your counties actually aren't technically in the Jim Crow South, so maybe you can see. But I'm just, again, it's a question of what are the stakes of the argument? How heavily do we want to weight this? And at what point are we making a new argument, or are we kind of trying to kind of nuance highly qualified?
Um, let me answer that by picking up the tail end of what we were talking about previously with the Neshoba County story. One question that I've gotten from time to time is, why did white people allow Black people to have rights? You know, what could explain this? And my answer has always been, white people needed Black people to have rights. You know, you think about, like, what is a sharecropping contract? It's a contract. Like that's what the sharecropping system is built on. It's built on the right of contract and the right of property. And so what that means to me, one of the things it means to me is that Black people are being exploited through law, not in spite of law. You know, the South is not a lawless place, but that doesn't necessarily make it kinder or nicer, you know, more livable for African Americans. It's the lawfulness that makes the exploitation so powerful. It's the things that white people are able to do that are perfectly legal. And, you know, for me, you know, what is that? I don't know if that so much changes anything for African Americans in the South, but for me, it certainly changes the way I think, the way that I see that era. You know, I don't think that it's fair to attribute the ferocious racial inequality in the South to exclusion from law. And in fact, I think it kind of lets law off the hook in a way, because so much of it was done through law. And then the second thing, as I said earlier, is that when you think about it that way, it, at least for me, gives uh, a different valence to the notion of colorblindness. Because these laws are colorblind.
Yeah.
And it's not, white people did not need to go to court and say the N-word. They didn't need to discriminate, if there were jury trials, they didn't need that. None of that was necessary. They didn't need to write, they did not need to write race into the statutes in order to get most of what they wanted. And it's not even because white people were sort of tacitly discriminating. It's because, as I said, when Black people come to court, they have a smaller pile of legal endowments. They can't hold out as long. It's the ordinary rules of property and contract, which are in fact colorblind, that enables this exploitation. And so, when I think about what's going on in today's Supreme Court, where you have the Chief Justice saying, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. That's just, many people have pointed out sort of the circularity of that statement, but what I'm showing is that the edifice of Jim Crow, like the very thing that John Roberts claims that we're now past, was built on the same principle that he thinks is going to save us from race discrimination.
Wow.
All right, let me jump in here. We just have 5 minutes left, and at the risk of going slightly over time, I want to throw in one last question, Dylan, from a former fellow. One of the great things about this series is that as former fellows know, the Humanities Center experience is built on fellows from different disciplines talking to each other almost every day about their work. This series allows fellows from different years who have never met each other to ask each other questions. And so here's a fellow from a number of years ago who is not from your cohort, but obviously from a different discipline. Let me paraphrase her question and put it to you quickly. And maybe it's a hard question to answer. So it may be more than we can handle in the time left. She says, I've been taken with the intersection with my own work on colonialism in Africa, when local musicians had a good deal of agency. My question, do you envision your methodology and your observations as potentially applicable, transferable, transposable to other contexts than US legal history?
Yes. And I say that because some of the approach, some of the sort of starting premises I took from my study of African history. That was one of the things that I did in graduate school. I've tried to maintain at least a toe in that field, much less than I would have liked to. But in African history, Jim mentioned a bit ago in passing this idea of the kin corporation. And that's, inspired by, if not borrowed directly from work by Africanists on kinship groups in Africa, the kinds of claims that they can exercise over people and things, both today and in the past. It's been very much a part of my work. And so while I haven't, I don't have the know-how to tell you how and where it might be applicable beyond the United States, I feel confident, or at least hopeful, that it could, simply because I took so much inspiration from my study of Africa.
Great. Okay. Thank you so much. That's a great place to stop. And tremendous thanks to you, Dylan, and you, Jim, for this great conversation. And Dylan, congratulations on the book. It's terrific to have you back at the center, even virtually. Let me just wrap up our business here in about a minute here and say that first, everyone who registered for today's event was automatically entered into a drawing to receive one of 3 copies of Dylan's book, Before the Movement. And so I'd like to announce today's winners. They are Angelica Martinez, Kenneth Waller, and Hannah Lacknit. We will be in touch with the 3 of you to give you your books. And finally, to the audience, thank you again for joining us virtually this afternoon. I hope that many of you can return either in person or online. Our next event in the winter quarter will feature an extremely provocative thinker about the future of the humanities, D. Venkat Rao from the English and Foreign Languages University in Hyderabad, India. He'll be here on January 21st at 4 p.m. Pacific. It's part of our series called All This Rising, the Humanities in the Next 10 Years. His talk is titled Critical Humanities Elsewhere Towards Pathways of a Responsive Reception. And of course, for those of you that aren't based locally, that event, like almost everything we do, will be offered on Zoom as well as in person here in the building. Plus, many more events lined up on the website. You can always visit us there, shc.stanford.edu. Dylan and Jim, audience, thank you all for being with us and best wishes for the new year.
Thank you.